Hello everybody. The next topic in your syllabus is legal procedure in medical legal cases. Now let's see what is inquest. Inquest in Latin means inquiro, meaning to seek or look for. It means an inquiry or investigation into the cause of an unnatural death. For example, burn, hanging, murder, rape murder, or any death that occurs under mysterious or suspicious circumstances, including death due to medical negligence. Now, what are the types of inquest? There are basically four types of inquest. Number one is the police inquest. Number two, the coroner's inquest. Number three, the magistrate's inquest. And number four, the medical examiner's system of inquest. Now, first of all, let's discuss what is the police inquest. It is the commonest type of inquest in Nepal and is held by a police officer not below the rank of a sub-inspector. The police officer receives the information about the suspicious death and visits the scene of death immediately, prepares Ghatnasthal Prakriti Muchulka and Last Judge Prakriti Muchulka, also known as inquest reports. Ghatnasthal Prakriti Muchulka contains description of the scene of death and Last Judge Prakriti Muchulka contains description of the dead body. These documents are prepared in presence of two local witnesses, one member of local government or any public official available, the informer of the case and alleged perpetrator if available. So in detail, if we have to understand what is Ghatnasthal Prakriti Muchulka, it is the detailed description of the scene and surroundings where the body was found, and Last Judge Prakriti Muchulka is the detailed description of the body along with the injuries seen on the body. But the detailed examination of the body actually takes place during medical legal post-mortem examination in the mortuary, which is performed by a registered and trained medical doctor. Now for the post-mortem examination, that is medical legal post-mortem examination, consent of the family is not required because medical legal post-mortem examination is the examination that is asked by the state to actually find the cause of death. The doctor performs post-mortem examination and gives cause of death and prepares autopsy report. The original copy of the autopsy report is given to the investigating police office and a copy is kept as a record in the hospital for future reference if the doctor is summoned by the court as an expert witness. Now after that, what happens when the post-mortem report is given to the investigating officer? The investigating officer will prepare a file which is also known as misil in Nepali, and he submits that misil or the file to the government attorney, also known as Sarkari Wakil in Nepali, and the Sarkari Wakil or the government attorney will further process the case. And this government attorney or Sarkari Wakil will submit the file to the court of law for hearing. Sunwai ko lagi. In the hearing process, two parties, that is plaintiff and defendant. Plaintiff means Badi and defendant means Pratibadi. They will both have trial in the court of law in front of the presiding judge, and the final verdict is given by the judge as guilty or not guilty and dispense punishment where liable as per the law of the nation. Now let's see another type of inquest, that is coroner's inquest. It is an inquiry conducted by a coroner into the cause of an unnatural death. Now, what is coroner? A coroner is a legally qualified investigating officer of the rank of a first-class magistrate, especially appointed by the state government to look into the cause of the unnatural death. Now, this system is prevalent in the many states of USA, UK, Canada, Australia, and Japan, but not in Nepal. Now, next type of inquest is the magistrate inquest. So, this type of inquest is held by a magistrate, especially in India, where death occurs in custody, dowry harassment and death, illegal police encounter deaths, exhumation, and any other death which the magistrate may think necessary. Now, a new word has emerged here, that is exhumation. So what is exhumation? So exhumation is digging out of dead body which might have been previously buried for re-examination. That is exhumation. So exhumation is lawful digging out of dead body for re-examination. Next type of inquest is the medical examiner's system. Now the medical examiner is an official who is both legally and medically qualified to conduct an inquest as well as the post-mortem examination. So usually medical examiners are the forensic medicine experts or forensic pathologist who is trained both legally and medically to conduct inquest as well as to conduct post-mortem examination. Now there are certain advantages and benefits of a medical examiner system of inquest. Main advantage of the medical examiner system is that the forensic medicine experts or the forensic pathologist or say the forensic medicine practicing doctor, he gets the chance to do the inquest. He goes to the scene of crime and it enables the doctor to estimate the time of death more accurately. Spurious evidences like abrasion and tearing of clothes during transport are minimized. Presence of blood stains, vomit, fecal stains, seminal stains, drag marks, vehicle tire marks, etc. at the scene of crime, which will relate to the body, may yield much more information concerning the death in comparison to the examination of the body alone at the mortuary. So this system is hence often regarded as the best system of inquest because the doctor, he has got opportunity to directly go to the scene and conduct the inquest, and he will have more idea regarding the actual manner and cause of death. Now let's see what is witness. So a witness is a person who has first-hand knowledge about a crime or event. Basically, witnesses are of two types, common witness and expert witness. Common witness or lay or ordinary witness is a common person who saw a crime being committed and narrates the facts observed by him. He is not allowed to draw conclusion from his observations. On the other hand, expert witness is the one who is an expert in some branch of art or science with essential academic qualification, professional training, and experiences in the concerned subject. Hence, he can also draw useful opinion and inference from the observations made by him and others. For example, forensic pathologist, chemical examiner, ballistic expert, laboratory professionals like you, etc. Now, there are few terms that you might come across: hostile witness and perjury. Let's see what is hostile witness. So, hostile witness is any witness, either common or expert, who is antagonistic to the party calling them and being unwilling to tell the truth. For example, a witness is called by a court, and in the court, either he denies for telling the truth or he is unwilling to tell the truth. What is perjury? Perjury is that it is a kind of offense where a witness will willfully tell untruth or make a misinterpretation under oath. So the perjury is the act of willfully telling an untruth or making a misrepresentation under oath. Now let's see what is medical evidence. It is the evidence produced by a medical man to prove or disprove guilt of the accused before the court. Now this medical evidence might be the only crucial at times available evidence on which entire case is dependent on, and also it might be the vital point, the only reliable evidence on which depends the liberty of the life of an individual. Therefore, the medical practitioner or medical professionals should draw a proper conclusion only after carefully making a note of all the facts observed by him. Let's see what are the types of medical evidence. Medical evidence could be documentary evidence, it could be oral evidence, or sometimes it might be circumstantial evidence. Now let's see what is documentary evidence. Documentary evidence means that the evidence given is in the form of some papers or documents for the inspection of the court. The witness usually does not have to appear personally in the court unless summoned by the court or unless called by the court. The documents may be of following types that we have already discussed. Now let's see what is dying declaration and dying deposition. These are also a form of documentary medical evidences. So dying declaration, it is the statement narrated by the dying person relating his condition or the circumstances leading to his impending death in the hospital. Whereas dying deposition, in some of the Western countries, there is a provision for the court to be brought to the dying man. A magistrate, type of judge, the accused, and his lawyer come to the bedside to record the statement of the dying man. So dying deposition is actually much more valuable in comparison to the dying declaration, because dying deposition is recorded in front of the judge, that is the magistrate, and the accused and his lawyers are also present at the process of taking statement of the dying man. Whereas dying declaration is recorded by the treating doctor and is not weighted as equally as dying deposition, because if the person survives, the dying declaration is invalid and victim has to go to the court to testify the cause of his condition. Let's see oral evidence. It includes all the facts and oral statements recorded in court by a witness relating to the cause under inquiry. There are mainly two types of oral evidence, direct or indirect. Direct refers to the evidence given by a person who actually saw or heard something in relation to the matter of fact under inquiry. Indirect oral evidence refers to the evidence given by a person who did not perceive it himself but merely heard it from someone else. It has little or no value in a court and is also known as hearsay evidence. Next is circumstantial evidence. This is the information and testimony presented by a party in a civil or criminal action that permit conclusions that indirectly establishes the existence or non-existence of a fact or event that the party seeks to prove. For example, where no one actually seen a murderer committing a murder, but several facts indicate that he has indeed committed a murder. For example, he might have been seen around the site of murder, or there might have been blood stains in his garments, or the weapon might have been recovered in his house. So all these circumstances which might point towards him that he has actually committed the crime. Now let's see attendance by medical professional in court as an expert witness. So being a graduate in BSc MLT, sometime you might be called by the court to give expert opinion. So when you reach the court, you should know some procedures how you are going to give your expert opinion. So when a medical person, if he or she might have to go to the court, if summoned by the court for an opinion as an expert witness, he or she must attend the court as specified in the summon letter and participate in the recording of medical evidence in the court. Now, you might wonder what is summon. Now, summon is the document issued by a court ordering a specific person to appear at a specific time for some specific purpose. So if you don't attend the court after receiving the summon, then you might be held guilty of contempt of court and may have to pay fine. So after reaching the court, while giving the expert opinion, you must know the court procedure, which are as follows. First step is the oath taking. After that, examination in chief, then cross-examination, after that, re-examination, and then questions asked by the court. Now let's see what is oath and actually what happens in the oath taking. So oath taking is the process where the witness swear in the name of God that he would say the truth, the whole truth, and nothing but the truth. After that, examination in chief starts. So examination in chief is led by the party who has called the witness to bring before the court the facts concerning the case. So in government prosecution cases, this is done by the public prosecutor, or also known as Sarkari Wakil in Nepal. The purpose of examination in chief is to get from the witness what he knows about the case, which will help the prosecution to establish his case. After that is the cross-examination. After completion of examination in chief, the next step is the cross-examination. So what happens in the cross-examination? In cross-examination, the opposing lawyer takes over cross-examination and he asks questions to the witness. The main objective of the cross-examination is to test the accuracy of statement made by the witness. After that is the re-examination. And re-examination is the step the prosecuting lawyer again starts asking questions from the witness. The main objective of re-examination is to clarify certain facts which are brought in by the cross-examination. Then the final step is the question asked by the court. If the judge thinks that some points have not been properly explored during the examination of the witness by either of the lawyers, then he himself may ask questions from the witness. For example, when you reach at the court and you sit for expert opinion, you sit in the court to give your expert opinion. So before you give your expert opinion, you have to take oath that you will speak the truth, the whole truth, nothing but the truth. After that, the prosecution lawyer or the Sarkari Wakil, he will ask you your expert opinion regarding the case. So when you give your expert opinion to the court, then the defendant lawyer will try to falsify your statement. That is cross-examination. He'll try to find out that the statement that you gave is somehow is false or it has got some drawbacks. Now, the defendant lawyer will try his best to falsify your statement. After this process, the defendant lawyer might have brought upon many dubious things or many unnecessary things. Now you will be again re-examined by the prosecution lawyer or the Sarkari Wakil to clarify all those dubious things that has been brought by the defendant lawyer. And this process is known as re-examination. After hearing all these statements, if the judge thinks that some of the points has not been explored properly, then he will put his questions to you directly. And that is the question asked by the court. After this process, after hearing the argument of the both parties, finally the verdict will be given by the judge. Now, when you are prepared to go to the court, you will have expenses occurred on the way. So to cover that expenses, you will be given some amount of money. And that money is known as conduct money. So what is conduct money? Conduct money is money paid to a person under the completion of a summon to witness. And this is paid for their expenses to attend the court. It generally incorporates a daily rate of each day the witness must attend in court with a 1-day minimum, plus a travel allowance to allow the witness to get to the place of the hearing or the court. Simply saying, conduct money is simply the sum of money given to the witness by the court to cover his traveling expenses. In our country, Nepal, conduct money is usually paid by the police office who carries out the entire investigation of the case. So, this much for today. We'll meet in next video. Thank you very much.